Welcome back. So our next panel is a whistleblower update, the impact on corporations and SEC enforcement. And very pleased to have, for the first time as the moderator, Jane Norberg, a partner at Arnold and Porter. So this year at Arnold and Porter, last year at this event, Jane was the chief of the office of the whistleblower of the SEC, only the second person to serve in that position. We'll get to the first one in a second. But Jane joined the SEC in 2012 and helped build the SEC's whistleblower program since near its inception. Jane, thanks so much for being with us today and for moderating, and welcome back to Private Practice.
Thank you.
Next, I'd like to introduce Russell Capone. He's a partner at Cooley. He's a former federal prosecutor, having served for more than 10 years at the U.S. Attorney's Office for the Southern District of New York. Russell, thanks so much for joining us.
Thanks for having me, Bruce.
Very pleased to introduce John Carney, and welcome back to the Securities Enforcement Forum. John's a partner at BakerHostetler, where he's co-leader of the firm's white-collar investigations and securities enforcement and litigation team. His experience is really remarkable. He's former securities fraud chief, an AUSA, an SEC senior counsel, a CPA at a Big Four accounting firm. Pretty much that's all there is to do, John. So congrats and welcome back, and good to see you.
It just proves that I can't hold a job, I suppose.
Next, I'd like to introduce Sean McKessy, who is a partner at Phillips and Cohen. Sean was the very first chief of the SEC's Office of the Whistleblower and built the foundation of that program. And now he's in private practice, and Sean fights for whistleblowers in the private sector. So Sean, thanks so much for joining us. Good to see you again.
Bruce, thanks for having me. And hat tip to David Lee Roth. This is the first time that everybody who has had the title chief of the SEC's Office of the Whistleblower are appearing together at one time. So
making history.
Good job on your part.
And the final piece of that puzzle is Emily Pasquinelli, who is the acting chief of the SEC's Office of the Whistleblower in the Division of Enforcement, a position that she took on following Jane's departure from the agency. Emily joined the SEC's Office of the Whistleblower in December 2012 and was promoted to deputy chief in May 2017. Emily, we really appreciate you joining us. Welcome and thank you.
It's good to be here. Thank you.
All right, Jane, it's all yours.
Thanks, and good afternoon, everybody, and thanks for hanging in there. I know it's been a long day, but we have a fantastic panel with some great subject matter experts on a really timely topic, because you literally can't turn on the news without seeing some headline about a whistleblower very publicly coming forward about any given topic. In addition, the SEC keeps making headlines with monetary awards in what feels like pretty much a daily basis. And the awards can be incredibly large, including a $114 million award given to a single whistleblower out of the SEC, and then recently a $200 million award to a single whistleblower out of the CFTC's whistleblower program. And so these truly eye-popping amounts certainly incentivize individuals to report information out to the regulator. And, the challenge for companies, in my opinion, is really how to harness that whistleblower information and get internal whistleblowers confident and comfortable reporting internally before they report out to the regulator. With all that said, I'm going to turn it over to Emily Pasquinelli, who is the steady hand serving as the acting chief in the SEC's whistleblower office still since I left in April. And so, Emily, why don't you go ahead and give us an update on the whistleblower program?
Thanks, Jane. Very happy to be back with both you and Sean here. It's been a long time. But so before I begin, I just wanted to give my standard disclaimer that the views and opinions that I express here today are those of my own and don't necessarily reflect those of the commission or other commission staff. You have certainly noticed an uptick in whistleblower awards over the last couple of years. We were really excited at the end of fiscal year 2020 when the SEC had made $175 million to 39 individuals, which was a record-breaking year for us. But that wasn't a blip. It wasn't an aberration, because we did it again in fiscal year 2021, actually eclipsing that record. So in fiscal year 2021, the SEC awarded over $564 million to 108 individuals. And so for those who are math people or keeping track, that means that the SEC made more awards, both in terms of the amount awarded as well as the number of individuals awarded, than in all prior years of the program combined. As you mentioned in September, it was pretty exciting for us. The chair announced that we had actually broken the $1 billion mark. And so it's pretty exciting to be speaking in terms of billions as opposed to millions now. So over $1.1 billion awarded to whistleblowers since the beginning of the program. And we started the fiscal year off with a $114 million award to an individual who provided incredibly significant information and substantial assistance. And then we ended the fiscal year in September with the second highest award, the $110 million award to an individual. And in that particular matter, the individual significantly contributed to an existing investigation, which shows you that not only are awards being made to people who significantly contribute, but they can also be substantial awards. In that particular matter, the individual also, received the award based on what we call independent analysis, which also shows you that it's not just insiders, employees who are whistleblowers who are receiving awards. It can be outsiders. It can be people who provide assessments, evaluations, analysis that really help move the needle in our investigations. And then in April, there was an over $50 million award to two joint whistleblowers whose information, the information is something that we would not have been able to find on our own. It was something difficult to detect and very complex, and really helped our enforcement staff in understanding the complexity of the transactions. And ultimately, the agency was able to, return tens of millions of dollars back to harmed investors. And so now we are 5 weeks into the new fiscal year. And in that short 5 weeks, the SEC has already made over $48 million in connection with 11 different enforcement matters. So I think you're going to see the same upward trend of this uptick in whistleblower awards. But it sort of brings me back to, the whole point of the whistleblower program is the protection of investors, protection of the markets. And so, since the beginning of the program, the SEC has been able to bring actions and ordered over $4.8 billion in financial remedies because of meritorious whistleblowers who have received awards under the program. So that's where we are in the award side. On the tip side, as you probably saw from last year's annual report to Congress that we do every November, there was a significant increase. There was about a 30% increase in the number of whistleblower tips. It was over 6,900 last fiscal year. And, our annual report to Congress is coming out in about 11 days. And you will see the numbers for fiscal year 2021. And I think you will see that there has been a continued interest, increased interest in the whistleblower program, and that those numbers will be increasing more. I think the program has a real a global reach. Getting tips from folks all over the world. We received tips last year from folks in over 130 countries, every state in the US. In terms of the allegation category, it's remained relatively consistent over the years. The highest allegation categories tend to be corporate disclosures and financials, offering fraud, manipulation. And I think that you're going to see that continued growth in those areas when you see our report.
Great. Emily, so can I just ask a follow-up question? So what about retaliation? So there's retaliation and 21F17, and I'm wondering what we can expect to see from the commission, which, you know, everything that I've heard from the chairman to the other commissioners to enforcement staff certainly seems to be an incredibly pro-whistleblower commission. And so I'm wondering about whistleblower protections and what we can expect to see in that area.
Yeah, I mean, absolutely. Retaliation remains a very high priority for us. I mean, the whistleblower program only works if employees feel like they can report to the SEC without fear of reprisal. So so far the SEC has brought 4 anti-retaliation actions, but we've also brought 14 Rule 21F17 cases. So there is a specific rule that basically says that individuals, companies cannot can't impede a person's ability to report directly to the SEC. And so there have been 14 in that space. The last fiscal year, in 21, we've seen a couple of cases, some activity in this area. The most recent one was in June of 2021. The SEC brought an action against Guggenheim Securities for violations of Rule 21F17 because of language in their training materials or compliance manual that prohibited folks from reporting to a regulator without first getting approval from legal compliance. And, you know, the commission found that that violated the spirit, the purpose of Section 21F and Rule 21F17. And then additionally, earlier in the year in February, the commission had brought an action against GBP Capital, which included both retaliation as well as Rule 20F17 charges. And so, I mean, I think that you're going to continue to see an interest in retaliation Rule 20F17 cases.
Thank you. And Emily, you talked a little bit about the tips. What are we seeing in terms of tips? So on previous panels today, there was a lot of talk around ESG and cyber and certainly disclosures. I'm curious, have you seen an uptick in tips in those areas?
Yeah, so absolutely. Cybersecurity disclosures controls for public companies and market participants, you know, they're important enforcement priorities, which I'm sure you've heard today, as well as ESG, which the chair has come out and said is one of his priorities. You know, we don't report that granular in terms of, cybersecurity or ESG related, but I can tell you that tips relating to corporate disclosures, which would relate to disclosure failures concerning cyber, climate, or other environmental concerns has gone up. And I think you'll see that reflected in the annual report. You know, one question I often get is in the area of cryptocurrencies, digital asset securities, because that's another area where the chair has said it's a priority. And so there was a specific complaint category that was added a couple of years ago so that we can better track crypto related and initial coin offering related tips. And so, you know, last year it was the 5th largest of the complaint category. And I think you're going to see a continued increase in interest in crypto when our report comes out in a few weeks.
Great. And what's the date of the report this year?
It's Monday, November 15th.
Okay, great.
Go live date. Yep.
Excellent. So Sean, let me ask you, we just heard from Emily what the SEC is seeing. I'm curious, you're representing whistleblowers. What are you seeing as the hot button issues? What are whistleblowers coming to you about?
So it tracks a lot of what Emily said. You know, I know my firm has gotten some ESG clients. Crypto is very big. I've got a large stable or inventory of investigations ongoing relative to crypto. Interestingly, we've had some people approach us about COVID-related SEC violations. And what do I mean by that? Instances where companies had longstanding issues inventory issues, shortfalls that they were going to have to reckon with at some point. And when COVID hit, they are using COVID to sweep a lot of problems under the rug and say, the only reason that we're experiencing these shortfalls or that our inventory levels are low or too high is because of COVID. And I've had a couple of people completely separate, different, and from different companies come and report a very similar story that we had been discussing these problems long before COVID, and now the company's trying to use COVID as a way to sweep things under the rug. So, and our job, we want to help the SEC to bring the cases that they want to bring. So we pay close attention to what the chairman is saying is a priority. So, when we're out and about talking to people, we make it clear that we're looking for people who have crypto information, ESG information, and obviously we get all of the bread and butter stuff as well, improper disclosures, accounting fraud, insider trading. But certainly, I would say right now the hottest thing in terms of anecdotally that we've gotten are in the crypto space, because I think we all agree this is a bit in hindsight, we'll look back and say this was a bit of the wild, wild west time where regulators and people participating in the space were racing with each other to kind of figure out what are the rules and what are the boundaries. And so we focus on those areas, and I have found the commission to be extremely receptive when I've called and said, I've got, this potential area in the crypto space.
Great, thank you. And Sean, let me just stick with you for a minute. But let's turn to the topic of public-facing whistleblowers. As we've all seen, whistleblowers can bring forth information and push it out into the public realm, and it can really result in, a PR nightmare at best for a company, and potentially, regulatory or criminal charges at worst for a company. And there's certainly been a debate about whether a whistleblower can take information from a company and what can they do with it. And so from your perspective as someone who represents whistleblowers, what protections does a whistleblower have if they report to the SEC or another regulator or law enforcement?
So the interesting thing is, from my perspective of the whistleblower's personal perspective, a lot of these public-facing whistleblowers are unusual. I think you and Emily would agree that most whistleblowers come forward and they're paranoid about their identity being revealed. And if anything, the confidentiality and the anonymity aspects of the program are the most interesting. Obviously, people would like to get paid and be protected from retaliation. And so, in these high-profile cases where you have, the Facebook whistleblower going very public with her allegations, I think it's important to be very thoughtful. And I think we all agree that every time an individual uses a company document to make an allegation, whether it be to a regulator or in the media, the company rightfully believes that information was stolen and is, inappropriately being used. So with that as context, I think from a statutory perspective, there is some statutory protection if quote unquote stolen documents or information is provided to a regulator, if it is determined that the reason that the person provided it to the regulator was in the public interest. And so there's that statutory, and that's a relatively broad statutory framework, which is why, incidentally, I think in addition to going to the media, the Facebook whistleblower availed herself of the SEC whistleblower program to get the combo, because I think it's an open question, and I think it's much less clear that if somebody appropriates documents, quote unquote, steals documents or materials from a company and only goes to the media, I think there's a vulnerability there because that regulatory public interest doesn't extend to that. And so it would have been surprising, and I think it reveals a bit of a strategy that this whistleblower, the Facebook whistleblower, went to the SEC first before having the Wall Street Journal article come out, so that there is at least the regulatory cover that this was information that had to be reported in the public interest. And if you think about, why is there this statutory protection? If there are things happening that a regulator, if they knew, could stop wrongdoing. And this extends beyond just the securities. Let's say you're aware that a nuclear reactor is about to blow up. The statutory framework wants people to feel emboldened to report that to a regulator to stop a disaster. That interest and the opportunity for something bad to be stopped is not obvious if you only report it to the media. The media can, certainly shine a light on things, but they can't take the kind of actions that a regulator can. So that's why I think it's important to be very thoughtful. If you're thinking about blowing the whistle, be aware that your company will be very mad if you use their information and will accuse you of stealing it, and being mindful of what protections there are only through availing yourself of a regulatory process.
So John, let me ask you from your perspective, because you obviously represent companies, and I'm sure that this has certainly happened in the past, where an employee has taken documents from a company, whether it be one or many documents. And I'm curious, what is your take on that? If they take those documents, they say, I'm taking these documents because I'm giving them to a regulator.
So I think Sean hit a lot of the points, hit the nail on the head with a lot of it. It's first of all, I think I look at it, my clients look at it, is it privileged or non-privileged documents? So if it's privileged documents, that's a whole special class of documents. But if it's just confidential documents, and as Sean said, if it's directly to the SEC and under statutory authority, I think you have to tell the company to stand down and work through the process. But if it's broader, if it's some to the media, then you have independent. There's a confidentiality agreement in place. Most companies, should have that in place. I think, you can tell them to, we can advise them to, take legal redress. But all that being said, it really comes down to the individual facts. I mean, if somebody took a very targeted amount of materials and it's not privileged, that's one thing. If somebody took a whole treasure trove of documents and things which actually could hurt the competitiveness of the company, I think from where the courts, it's still kind of developing case law. The courts are going to be, as I think Sean, got the right tone. It's like they're going to be much less likely to protect if they just wholesale took the whole computer, and companies still do have rights versus just going with the SEC or some nuclear regulatory authority. So I think that's the first thing. And then even in privileged areas where it's privileged materials, I think it's much better, obviously much better for the company. We look at it as there's no good reason, even though there have been some cases, when there's a general counsel involved, there's something that they have cited that there might have been a possibility of a waiver or a fact that the attorney-client privilege had to surrender to the public interest. But still, with that, I think, and then of course I won't go too long about it. But then, of course, there's always the issues that come. If it is privileged materials, then there's all the state ethics rules too about attorneys getting. And I'm sure that's something your office has dealt with, Jane, in the past, and you guys do. Is like, what do you do when you get privileged materials?
Yeah,
right.
I just expand on that real quick, Jane? So leaving aside privileged materials, which I think we all agree that the SEC, a whistleblower office, and nobody at the SEC wants to get. But I think it's important for this audience to understand that, let's assume it's not privileged information, but the company has a justifiable reason to believe that these documents were stolen or were appropriated in contravention of their employment agreement. It's important for this audience to know that the SEC is agnostic at best as to that. What I mean by that is if they get actionable intelligence and you as a company feel like that the employee shouldn't have taken it, the SEC, and I know that this has been asked several times, why does the SEC even take this, or why won't they take our side, the company's side, because this was improperly taken? And I think it's fair to say the SEC would not be able to bring a lot of cases if they agreed with companies, okay, you gave us information you shouldn't have, so we're not going to act on it. That's not the case. They're going to work on that actionable intelligence, and they're not going to, basically they're going to say, we don't have a dog in that fight. And if you as a company want to take it up, file a lawsuit against your employee for violating the contract, that's basically up to you, but that's not something that the SEC is going to take into account. They're going to use that information.
Well, Sean, let me just ask you one other question following up on that. What is your view of, there's Rule 21F17, which Emily mentioned right up front, right, where no one can take any action to impede someone from reporting a possible securities law violation to the commission. And the commission has brought, I think it's 14 actions to date under that. Is it your view that if a company says, basically you can't take our documents, is that potentially a violation of Rule 21F17?
Well, my sense is that's probably a little broader than the commission would be comfortable with. If you look at the language, 2017 says if you take any action, including enforcing or threatening to enforce a confidentiality agreement. Now, that said, I know that my successor as the chief of the office, who looks a lot like you, did make it clear that put yourself in a non-lawyer's position, and if you're making communications to a person that implies or suggests that if you report to the SEC, you do it at your own peril, then that's something the SEC is going to look very closely at. My own view is that may be a little bit broader than, and it's shocking for me to say that because I love 21F17A and has been an advocate for it all along. But I think just reminding an individual that these documents are ours and anything you created is ours. And the other point I would make is, as an SEC employee, we were told by the SEC that everything that we created was the property of the SEC. So it'd be a little bit hypocritical for the SEC to turn around and say, you're not governed by the same rules that we have to be governed by. But I think it's, as with everything, we lawyers always say it's always fact and circumstances based. I think if you had a clean record where all you were doing was reminding someone that once you're done working here, you turn over your documents, I don't think that in and of itself would be violative.
And so let me just ask Russell. Let me ask you. I know that you've been on the government side, and now you're in private practice and advising companies. So, what advice would you have if documents were taken, putting aside the regulator? What about if they're just put out there in the public realm, right, to the media or another third party? What defenses does a company have?
Yeah, well, look, it's certainly the case that in some instances, going to the media could be part of a whistleblower strategy. As Sean, I think, said, it's not common. And of course, going to the press can't necessarily, net the same financial benefits like the whistleblower program. But the whistleblower might not go to the press publicly, right? It might just be part of a campaign to get this out there, and so that there is some sort of public pressure on the government, on the SEC, to look into this. As others have said, obviously the whistleblower is not going to have the same protections for disclosing confidential information to the media. At least, if it's confidential information, trade secrets covered by an NDA, the company likely will have legal recourse against the whistleblower. But that's the legal side. Practically, optically, strategically, is it always going to be the best course? Obviously, you haven't. Somebody mentioned Facebook. You haven't seen legal action to this point from Facebook, and I think it often may be the case that even though from a legal standpoint, there a lawsuit could be brought, it's not going to make strategic or business sense. Be in a different situation if the whistleblower has not actually provided the information yet to the media, but it has threatened it or raised it or contemplated it, and the calculus would probably be different at that point. And in that circumstance, if it's protected by an NDA or confidentiality agreement, you certainly would want, or likely would want, to engage with the whistleblower to remind him or her about that agreement. I guess you also might, I don't think that threatening litigation against the whistleblower for disclosing things to third parties or the media, as opposed to the SEC or other regulators, could be considered or construed as retaliatory because it's within your rights. But obviously, it's still an area that you need to be careful with in general. And obviously it's best practice. And I think most big companies do have confidentiality agreements in place in the first instance to hopefully prevent it from getting to that point.
Thank you. And so let me just turn now to internal reporting and internal investigations. If a company is lucky enough to have a whistleblower report internally before they go to the regulator, that's the best case scenario for a company, right? Because they have a chance to take a look at the issue, do an internal investigation if it's appropriate, and remediate before a regulator ends up, showing up at their door. So Russell, let me stick with you on this. So if there is a whistleblower or a suspected whistleblower on a matter, can you give us some best practices in handling the internal investigation?
Sure. First thing I'd say is take the whistleblower seriously, take the allegations seriously, and regardless of the circumstances, don't write it off either because you find the allegations unlikely to be true or believe the whistleblower is not credible or disgruntled and trying to cause trouble at the outset. Take it seriously. Assess early on whether to involve outside counsel, even if it's just for a consult. Not every situation is going to call for engaging outside counsel, but consider it, assess it. Obviously, relevant factors would be how high up the allegations go. How is this sort of an isolated or discrete incident, or is it far-reaching? How inappropriate is the conduct? If the whistleblower is anonymous, don't spend time trying to figure out who it is. And if the whistleblower is not anonymous, to the extent practicable, limit the number of people who know his or her identity. It can be more distracting than helpful, I think, to try to identify the whistleblower. And if the whistleblower is anonymous, it is more difficult, obviously, to retaliate or to take actions that could be construed as retaliatory. So that's a reason why, even if certain officials and counsel needs to know the whistleblower's identity, keep that circle limited. Throughout the investigation, be very, very mindful of actions that risk being, or at a minimum, even coming across as retaliatory, and discuss those with counsel when appropriate. Just as one example that you might not sort of think of, there's a recent Fifth Circuit case that found, this is in the Sarbanes-Oxley anti-retaliation context, but even identifying a whistleblower in a preservation notice was considered an adverse action. If it is a situation where the whistleblower is not anonymous, so you know the identity of the whistleblower and they're willing to engage with him or her early and frequently, and do it respectfully. It's important to attempt to gain the whistleblower's confidence. If you can, make clear the allegations are taken seriously, so you can get all the facts and the whistleblower's perspective as soon as possible, because obviously there could come a point where if you have access to the whistleblower in the first place, where you would no longer have access to the whistleblower. And at the same time, assume that anything you're saying, any conversations that you have with the whistleblower could ultimately, or in fact are likely to ultimately be reported back to the staff, or if not an SEC matter, whatever the relevant regulator or government entity is. In terms of the investigation itself, a lot of this is sort of best practices for investigations generally, but have a clear understanding of who the team is, who has access to what, so that the details are kept within that group. Put a lit hold in place. In most instances, that's going to be appropriate, as you would with any investigation. Assess the steps that you need to take, but where is all the material you need? Do you need access to emails and records and things like that? And assess the likelihood that the SEC or whatever the relevant regulator is may already be aware of the facts from the whistleblower or otherwise, because that's obviously going to inform both the pace of the investigation and your decision on when and whether to disclose. The last thing I'd say is that the company should be prepared for the allegations in advance. The substance may catch you off guard, but the game plan should not be something that you're creating ad hoc. There should, particularly for larger companies, there should be a process in place, policies in place, and means by which whistleblowers can actually reach out and report. That should be clear and transparent, and having that process and clear ways to report misconduct can itself be very helpful, both because it contributes, to a culture of openness, and it makes it more likely, obviously, that the whistleblower is going to avail himself or herself of the hotline or whatever it is that's in place to be able to report those allegations.
Great, thank you. And Emily, can you remind me, if you know off the top of your head, what is the percentage of whistleblowers who've been paid under the program that say that they reported internally?
Yeah, in our report last year, I think it was around 80%. I mean, what we have found is that the vast majority of cases, when you have an insider whistleblower and employee, they do tend to report internally before reporting to the SEC. And so I think exactly what Russell just said, he sort of hit the nail on the head, that a lot of times these folks will report to the SEC after internally reporting because they didn't think the company took them seriously, that they raised the concern, they're brushed off, they were not taken seriously, the company kept them in the dark about what was happening, they got frustrated, they got fed up, and then they reported.
Interesting. I mean, I think 80% is a pretty high number. I mean, when I think about that, because you're talking about whistleblowers who got paid under the program, right? So you're talking about people who had good, actionable information that someone at their company knew. And so when you think about it that way, in 80% of the cases, someone at these companies knew about the information, and either the information potentially got lost somewhere, in middle management, never got reported where it needed to go internally, or, as Emily and Russell both pointed out, it's possible that the whistleblower just felt that the company was not taking action, even if they were, perhaps it was a lack of communication with that whistleblower. So it does raise interesting questions. Sean, let me ask you, what do you hear from whistleblowers? Where, I'm sure you get them right before they go to the SEC. So the question is what are they saying? Like, so those who have reported internally, where are they saying the company, in their perception, got it wrong?
Yeah, it echoes almost everything we just heard. And I guess I would add, just anecdotally, I'm just thinking off the top of my head, I think the only times that I've had a potential client come to me to report on their current or former company that said that they didn't report it internally is instances where the internal process was broken and they felt like if they went, they would be blowing the whistle on the people that they were reporting on. So the instinct is always, employees always have the instinct of hanging with their company and getting things done internally. This idea that the creation of this program created a groundswell of people who just want to run to the SEC. It just hasn't squared. It never squared with me, instinctually, and the data doesn't prove it out. And now that I'm on this side, literally everybody who comes to me about their current or former company only comes after they have been treated poorly or fired after they raised it, or they were swept under the rug. They were told, this is not your job. Go back to your real job. Don't talk about this anymore. Or black box, right? And so the only thing I would add to Russell's tips is be as transparent as you can back to the whistleblower. It's harder, obviously, when they report anonymously in a helpline, but the more you can keep them engaged and say, listen, we heard you, and here's what we did, here's what we looked at, and here's why your allegations were found not to be meritorious. That's, in my mind, 9 times out of 10, that's going to put it to bed. What doesn't put it to bed is we looked into it, there was nothing to it, go back to your office, go back to your cubicle, get back to work and stop asking any questions. The more you can talk about, and maybe there's reasons you can't go into all of the findings or some of the legal theories or whatever it may be, but the more you can say, this is the process we followed, and you were heard. we talked to the following people. We talked to everybody who has information about this. We hired outside. The more you can reassure the whistleblower that they've been heard, the better it is for you. And maybe I shouldn't say this because it's worse for me, because I'd rather you not do that and drive clients to come to me. But and I say that somewhat comically, but at the end of the day, there's really no substitute for treating whistleblowers like a human being that deserves to be respected for raising their issues, even if what they're saying is completely out of line with the reality. For whatever reason, they feel strongly enough to have raised their hand internally, and that's what you want them to do. So reward them for doing it, and make sure that they feel at the end of the process, win, lose, draw, that they were heard and they were respected in raising it.
Yeah, and I just want to mention something and then pivot to our last topic, because I know we're down to our last 5 minutes. But something that I think companies should be thinking about is now, we're in this COVID environment. We're still in this COVID environment 18 months later. Some companies are going back to work. Some places are staying remote. Some places it's a hybrid. And listening to Emily talk about the increase in tips, it does make me wonder, whether internal reporting is the same, and whether employees who are home feel that same connection to their workplace and have those same internal reporting channels and feel good about using those internal reporting channels. And I just throw that out there as something for companies to think about, whether they can still capture that information as successfully as they had in the past. But just turning to John quickly, our last topic that I wanted to cover briefly is about, perhaps a bad faith whistleblower or somebody who is culpable in a matter. And I know they're two separate things. But John, what advice do you give companies who suspect that there is potentially a whistleblower who is giving information perhaps in bad faith or is a bad actor, reporting internally, either reporting internally or directly to the regulator?
Yeah, I mean, I've had a number of bad faith whistleblowers where I've represented some major corporations. And so I kind of come up with a 4-point plan for this is, first thing, being incredibly upfront with the staff. And the fact that we're going to do more, and we're going to do more faster than you would ever see and come to you. So give us a little time to get on top of this if it's fresh to us, or if we had an internal investigation, come right to you. Very often there's an impossibility or misunderstanding by the whistleblowers, and pointing out to the staff that why this person didn't have visibility and why there's a logical explanation. I had a situation where somebody thought the loss reserves were too low in South America, but they were too high in North America, and collectively in the balance sheet, they were properly stated. But yet we had to go through the whole brouhaha about that and spend a fair amount of money. So convince people that it's just impossible. Third thing I'd like to do is actually, if you have to, is to show the bad faith of the whistleblower, show the fact that they were terminated for cause unrelated to the whistleblowing activity, but for misconduct, or that they resigned voluntarily and then and after they resigned decided to do this when they had bias. We've certainly seen that in a number of cases. And then from representing my clients, I want to avoid the commission getting, the staff getting too invested in something that's not there. And so I've had a lot of success in being able to just really be upfront and actually show it. And of course, never taking any, shots, retaliation against the whistleblower, just by showing, hey, look, here's all the reasons why. And picking up really quickly on Sean's point, and in situations like that, I've seen situations where we do disclose as much of the investigation to them to try to get them comfortable, but they refuse to accept it. And sometimes they refuse to accept it on grounds that they're the righteous white knight trying to do something, and they can't believe the fact that it's not there. And they become so emboldened with this concept of being a whistleblower, and I've met some of them, that they lose the ability to think clearly about it. And frankly, like Sean, we'd love to have them go to someone like you, because you could do the diligence for the defense of the company and probably stop them in the first place.
Thanks. And I know that we have literally a minute. And so what I'd love to do is just give the panelists just the final word, kind of speed round. What do you think is the most important piece of advice for companies with respect to whistleblowers? And I'll start with Emily.
Focus on the substance of the allegations, whether they can be corroborated, substantiated, and not the character of the whistleblower. Avoid character assassination.
John?
Everything Russell said, except do hire outside counsel to get an independent look at it and get it done fast.
Sean?
Contemporaneous documentation of poor performance. You do not want to put yourself in a position where you're telling the staff the reason the person was fired is because they were a bad employee, and then turn over years of great performance because you didn't want to do the hard work to tell people that they're poor performers.
Russell?
Have a process in place that's transparent in order for whistleblowers to be able to report to you so that it is reported to you in the first instance.
Great. Thank you.
Jane, do you have anything?
Mine would be think about this COVID environment and ways to get folks to report internally, even when they're sitting at home and can very easily type in a tip to the SEC on their computer.
Fantastic. Thank you, Jane. Great job moderating. And, Russell, Emily, John, Sean, thank you so much for joining us today. A great whistleblower panel. I'm honored that it was the first time we've had Emily, Sean, and Jane on a panel, and John and Russell really rounded out great. So thank you again. The next panel is in 5 minutes. It's the last panel of the day. It's on cryptocurrency regulation and enforcement. Should be a really interesting panel. So we'll see you in 5 minutes. Thank you.